Good afternoon. My name is Karen Harding and I'm a criminal defence barrister from Auckland, New Zealand. I'm principal of the law firm Karen Harding Law, Barristers and Solicitors. I'm essentially a sole practitioner and I'm usually involved in defending criminal and drink driving charges here at the Auckland District Court and the related courts around Auckland. In January 2015, I travelled to Indonesia where I met with a number of Indonesian gentlemen who had worked in New Zealand as fishermen on Korean fishing vessels. And they reported to me their experiences in New Zealand on the Sajo Oyang vessels, Oyang 77 and Oyang 70. That was very disturbing what they told me. Essentially, they had worked on vessels in New Zealand waters with New Zealand work permits, and they were not paid the New Zealand minimum wage. You might think, well, why is that disturbing? Well, they worked 18 to 20 hours a day, 7 days a week, for the length of their contracts, and the majority of each of these fishermen worked 2-year contracts. Sometimes they worked longer than 20 hours in a shift, so in their roles, which might be on deck, and they're involved with hauling the nets and that kind of thing, or they could be down below in the vessel in the freezer area, sorting and freezing the fish. When they had a big catch, and there was a lot of big catches because New Zealand has a fabulous fishing resources, they would sometimes be up more than 24 hours in a row, and their sleep was constantly interrupted, and they just lived a state of exhaustion. There was no personal time, and the facilities on the ship are covered by something that's called abject conditions, and that they were just simply terrible and unacceptable. They had insects in their food, fleas, including in their beds and the food, cockroaches everywhere, their bodies bitten by cockroaches, a toilet basically that all the Indonesian fishermen had to use. So you might have like 30 fishermen on a ship. It's just disgusting. And rather than individual showers, there was just like one kind of big bath, and it was just like really gross. And they all had to share it together and use the same bath water. So it was salt water as well, so they didn't get access to fresh water, and they're washing their bodies and their clothes in salt water. So you can imagine that you're working 18 to 20 hours a day, every day, Monday to Sunday, for 2 years, how exhausted you would be doing manly physical work on the fishing vessels. And the wages were under a contract that said it was US $200 a month. Some got $220 a month, and some got up to $290, but most were on $200 a month. The New Zealand minimum wage at the time certainly provided for a reasonable kind of lifestyle, and none of that is covered in it. And they also perhaps should have been paid according to the sleepovers, because they were up at the beck and call of their employer. So collectively they were just basically economically exploited and abused. And in the background to this, to get this fabulous job in New Zealand, they had to put up security. And the security that they put up was their parents' house or their paddy fields. So that meant that it was a guarantee, and if they left the vessel before the contract was up, that the agent who arranged it for the Sajo Ong Coprtaion would seize that property, which would render their family homeless. If the sailor didn't have a house, his parents didn't have a house, then they had to put up what else they had. That might be a vehicle, or their school certificate. A lot of the fishermen didn't even finish primary school, so if you manage to finish primary school and get a certificate for that, it's a very valuable document, and to keep hold of that is really unfair because it's just irreplaceable. And one case in relation to security, he had nothing, he hadn't even finished primary school, so he put up his mosque leader's house certificate. So can you imagine when he goes there and finds out he's got to work 20 something hours a day, he's only getting $200 a month, he's got to live in cockroach infested rooms in wet bedding. There was also abuse going on the ship, so there was verbal abuse, racial abuse, bullying. There were physical assaults. Some of the seamen that I represented were dragged across the ship by senior Korean officers, and there was sexual abuse on the vessels as well. Some of my clients reported that they were raped, and not just once. It was a repetitive, ongoing conduct, causing him great emotional distress. So can you imagine someone like that, and he puts up that kind of security? If he's witnessing it or experiencing it, he can't leave because he can't risk the important people in his village losing their property. One of my other clients, he didn't have anything, and his next door neighbour put up his vehicle as security. So it really put people in a really difficult position. And the thing is, this happened in New Zealand. It's happened in New Zealand. And these gentlemen, and in the end I've got 30 fishermen now. At the time I filed legal proceedings, there was 26. They want justice. They want to be paid what they're legally entitled to. And that is according to the New Zealand minimum wage. Plus they're allowed an extra top-up, which is just an extra $1.75 to $2 an hour, depending on the time period worked, under the Code of Practice for Foreign Fishing Crew that was passed in 2006, on top of the New Zealand minimum rate, which did vary each year. So they want to get paid, and they want some justice and an apology. So I filed legal proceedings in New Zealand. I found that the vessels were forfeited, so we couldn't proceed in Admiralty in relation to doing an in-ring proceedings. An in-ring proceedings is when you arrest a vessel and you put it through a high court in the Admiralty jurisdiction, which is a court that deals with things that happen at sea, and you seek to sell that vessel to pay the wages. So we couldn't apply in ring because the Sajo Ong Corporation's vessels, Oyang 77 and Oyang 75, that had been in New Zealand, were involved in serious fisheries crimes, and their captains got convicted. And under the Fisheries Act, a consequence of getting convicted is that the vessels get forfeited to the Crown, free and clear, so that any debts owed to anybody, including wages, is gone, and it just all goes to the Crown. And I also have clients that worked on another vessel called Oyang 70. That was a third vessel that was fishing in New Zealand, and that had all the same problems, except that vessel actually sank and 6 people died. So fortunately my 2 people managed to get off that boat before it sank, because their contracts finished prior to that. And so they can't possibly sell a vessel that sank. There's something called a maritime lien, which means that you have a wages lien over a vessel until that last plank is gone. And then once that last plank is gone, when it's sunk or burnt, you then have to make a claim over a sister ship. So what we wanted to do is to make a claim over the sister ship, Oyang 75, that had been forfeited to the New Zealand Crown for the fisheries crimes. So we applied under Section 256 of the Fisheries Act 1996 to get relief from the effects of forfeiture over the sister vessel Oyang 75. And the crew in relation to Oyang 77, their vessel was forfeited for the fishing crimes that their captains were involved in. So we also applied for relief for forfeiture from them over that ship, the Oyang 70, but also over the sister ship Oyang 75. Oyang 77 is a very old ship, and the valuation in 2009 was 1.5 million New Zealand. It looks pretty terrible in the photographs I've seen. It has been described as a rust bucket. It's still in use, so presumably it's useful, but it was very unpleasant for the crew to live on, and it certainly is not in the best of shape. It's old. Oyang 75 is a much nicer vessel. It's newer. It was the replacement for the sunk ship, the Oyang 70, and that had a valuation around that same that I've seen, which was an American valuation of US 7.5 to 8 million US. So the sale of that vessel, Oyang 75, would be enough to pay the wages for the crew for Oyang 70 and Oyang 77 that I'm representing. On its own, Oyang 77 wouldn't be enough, I don't think, to pay the wages for the Oyang 77 crew, because whenever you sell the ship, you have a lot of costs in selling the ship, even if you use international tender, and also under the provisions of the Act, the costs of the investigation into the fishing crimes has to be paid for out of the ship. That was obviously a very long investigation. The cost of the prosecution, the cost of the court case, paying for the Crown solicitors to do it, that has to be paid out of it. Also, the captains never paid any of their fines, and they were fined hundreds of thousands of dollars, and so the Crown wants to have those fines paid out of those vessels as well. So by the time all that happens, there's just not really going to be any money left, because it's really substantial costs. So the crew from Oyang 77 also want to seek release from forfeiture over the sister ship Oyang 75, and we say that's necessary in the justice of the situation. So we filed the proceedings under Section 256 of the Fisheries Act to seek relief from the effects of forfeiture, because otherwise the Crown get to just keep these vessels and sell them and keep all the money from them, and the New Zealand Crown just gets a little bit richer, which they can just blow on not a lot. But it would make a huge difference to my fishermen to get paid for the work that they have done. Also, the Sajo Ong Coprtaion have also applied for relief from forfeiture, and they have applied to basically redeem the vessels and get them back. And before I came along and filed the proceedings in April 2015, it seemed to me that the Crown and the Sajo Ong Coprtaion were working out a deal in which to do that, to get what they call redemption, which I suppose means they pay some sort of monetary cost or fine or money to cover perhaps those things to do with the investigation and the fines and whatnot, and get the vessels back. And they really want the vessels back because they're currently using them. So vessels were released on a bond. The exact amount of the bond money for Oyang 75 and the exact amount of bond money for Oyang 77 has not been disclosed to me, so I don't know how much it is. I believe it is in the Ministry of Primary Industries trust account. I can't be sure. And they have been released to go fishing, and they've been internationally fishing around Uruguay and going backwards and forwards, across the Pacific and the Atlantic Ocean, making money for the Sajo Ong Coprtaion. So they haven't had a lot of incentive to wrap things up quickly, and they certainly couldn't once I started filing applications. So I filed these applications in April. I only had a short time to prepare everything. I only got 3 weeks really to prepare all that information, because there was a hearing set for the 16th of April 2015 for the Sajo Ong Coprtaiion's application for relief from forfeiture. So I filed all our applications by the 10th of April for the first 26 people that I was representing. Then we had a major hearing on the 16th of April, which was really who can apply for relief from forfeiture. As well as my 26 fishermen, there were 2 private individuals who were seeking relief from forfeiture. Mr. Darren Colson, he was a New Zealand expert fisherman who tried to help various fishermen who worked on Oyang vessels to try to get some kind of justice, and he was seeking some quite substantial money to recompense himself for the costs that he spent in trying to help these destitute people get access to justice. Well, that application was declined, and there was another lady who was actually an interpreter, and she spent at least $20,000, I think, of her own money trying to help these desperate people while they were in New Zealand when they got off vessels, to try to help them. A lot of the people she was trying to help came off the Oyang 75 vessel, and at that hearing on the 16th of April 2015, the Crown agreed that her interpretation, her services as an interpreter, were really valuable, and they agreed they were going to pay that without having to sell the vessel to do it. In relation to the applications that the fishermen filed, His Honour Judge Keller at the Christchurch District Court, which is the court that was involved in the forfeiture hearings that heard the fisheries crimes and confiscated the vessels, he determined that the fishermen could make an application under Section 256 1B Roman numerals 2 to apply for relief from forfeiture to seek their unpaid wages. It doesn't mean that we won the whole application, because you have to go on through a process through 11 subsections to get the wages determined, and then for the court to decide whether or not to sell a vessel to pay those wages. But to be able to get to a position for the court to determine how much your wages are owing, and then to decide whether to sell the vessel or not, you have to be able to apply. So you have to be, I suppose, like lotto, you have to get a ticket to win, or you have to be in to win. So you have to be allowed to apply to be able to go, in simple terms. So then that was a little bit more complicated. That the judge was then asked in July of the same year, 2015, about the whole sistership issue, because that hadn't really been fully addressed in the decision of 22 April 2015. And the sistership application was made under a slightly different subsection. It was made under section 256 round brackets 1 round brackets little c of the Fisheries Act 1996 to seek relief from forfeiture out of other forfeit property. So in relation to that, what we were saying is that Oyang 75 was forfeited property. In relation to these clients who didn't work on it was other forfeit property, and that they had an interest in it in their unpaid wages. His Honour Judge Keller declined to let the people who work for the Sajo Ong Corporation on their vessels but not on Oyang 75 apply over Oyang 75. So that meant in particular that the crew from Oyang 70 were not allowed to apply for relief from forfeiture, were not able to be in line to get their wages out of any sold vessels. So that meant that the crew that worked on the vessel that sank were never going to get paid. And so I was really extremely concerned about that whole situation, because we're just not in a position to arrest any other ships. The vessels are forfeited and it sank, the one that they worked on. So I applied, when that decision was declined, what we call an appeal, and I appealed to the Christchurch High Court, and that's because these cases are all going on in Christchurch, and New Zealand is in the South Island. And so the decision in July was appealed. The Sajo Ong Corporation appealed the decision also that was released by Judge Keller on the 22nd of April 2015, that we could apply to have wages determined and to get relief from forfeiture. So both appeals, the Sajo Ong appeal and the appeal over the sister ship under subsection C, were referred to the High Court on an appeal, and a hearing was allocated for that for the 8th of September 2015, so it's quite a long wait. Then there was a long wait to get the decision, and the decision wasn't released until the 18th of December 2015, and that decision determined that yes, the fishermen can apply for relief from forfeiture under section 256 round brackets 1 round brackets little b round brackets little Roman numerals 2 over the forfeited property. And also they could apply to section 256 round brackets 1 round brackets little c of 256 of the Fisheries Act over the other forfeit property, being the sister ship, to get their wages, because basically anything else would be completely unjust. And the judge accepted my submissions in respect of that. The Crown fought me, the Sajo Ong Corporation fought me, and they both opposed the crew of the sunken vessel being able to get their wages out of forfeit vessels, or for the crew from the Oyang 77 to get their wages out of Oyang 75. So it was a brilliant judgment, I thought. And now what's happened is that the Sajo Ong Corporation applied for leave to appeal that High Court decision that was released on the 18th of December 2015. And that was, leave to appeal was granted. And now we're coming up in a few working days, two working days, to have an appeal in the Court of Appeal in Wellington. This is a civil case, it's an Admiralty case, it's civil, and it's going to be in the Court of Appeal, and we have our first day for that on the 12th of October. And we had to file an extensive amount of legal submissions about that. Basically, I'm going to be submitting that the High Court judge, His Honour Judge Davidson, was right. And there's just unconscionable not to allow a fisherman from sunken vessel to get relief from vessel forfeiture from another vessel forfeited by their employer. And that they should be able to apply for relief from forfeiture, and anything else is just unjust. But now I'm in the position where I've got to fight the Crown again, being the Ministry of Primary Industries. They just want to keep the boat for themselves. And their position basically is that, oh well, you should have applied in rem to sell the Oyang 75 before it got forfeited. You know, like that was possible. Just impossible. So it's a frustrating little case in its own way, because you know these people don't have resources. They took about 5 years to get a lawyer, and how they're supposed to, you know, like whip around and find a magical lawyer who's going to go around and arrest a vessel. It's just ridiculous, really. But it was also forfeited for fishing crimes at quite an early stage. So the Oyang 75 was forfeited on the 21st of September 2012, and I had my Oyang 77 crew coming off the vessel in December 2011, so it was the year before, but they didn't have a lawyer, they didn't know their rights, they didn't know, you know, what the minimum wage was, they didn't have any access to justice, no one wanted to represent them, they couldn't find a lawyer, you know, there's no Charlie's Angels to help them. And then I came along, but I didn't come along until January 2015, which is, you know, years later, and the Crown already got the vessel. But I don't see that causes really any substantial delay on anything, because nothing's happened in the district court about these forfeiture hearings, because on the vessel being forfeited on the 21st of September 2012, the Sajo Oyang applied for relief. Another vessel got forfeited on the 3rd of September 2014. The Sajo Ong Coprtaion applied for relief shortly thereafter on the 15th of September 2014. But they appealed. The Sajo Ong Coprtaion then spent all the way up until the end of 2014, I think, appealing their situation, trying to see if they could be heard for special reasons for the vessel not to be forfeited. And they went to the High Court, they did judicial review, they went to the High Court, appealed, then they went to the Court of Appeal, and they even applied all the way to the Supreme Court. And the Court of Appeal said no, you know, no grounds here, you can't appeal, you know, you're no standing, and the vessel's a forfeit. And the Supreme Court didn't want to hear the appeal, so they spent, you know, 2 years going round and round and round appealing everything, just in time for my crew to get a lawyer and make an application to apply for relief from forfeiture. So, you know, there was some sun shining on these crew members at the point that I turned up to help them. And then the hearing, the only hearing ever set in person at the Christchurch District Court to do something about these forfeiture applications for relief from forfeiture, was already preset the year before for the 16th of April 2015. And I became counsel in January 2015, returned back to New Zealand in February 2015. I found out the vessels were forfeited after I started making Google research in the computer and found out about these proceedings in Christchurch. And then I filed the proceedings, and I got all the paperwork in for the first 26 in time for that first hearing. So we aren't making any delays, and the way things worked out, it hasn't inconvenienced anyone, and the vessels are off out fishing, making the company money, so they've not lost out a dime. And these vessels were involved in a really serious crime. Meanwhile, years and years have gone past, and no one's been paid. So, I mean, the crew started working from the 16th of December 2007 on some vessels. The earliest one I have is started working on the 13th of December 2007, and he worked up till 2009 in December. And some of the other crew members on Oyang 77 sort of started at various times from 2009, finishing in 2010, sort of at the end of the year, and Summers Late finishing in October 2011. So it's been a really long time that they did this work, and it's been such a long time to wait to get paid. And when I added up all their wages, it's appalling. And there's just so many fishermen, and it's millions of dollars. And if this vessel Oyang 75 can be sold, then the fishermen can all get paid, and they don't have to be in poverty anymore. They can get some justice for what's happened to them, because it's not acceptable to come to New Zealand and get a New Zealand work permit to work for a particular company, being the Sajo Ong Coprtaion, in partnership that was with a New Zealand company at the time, which was Southern Storm Fishing 2007 Limited, now struck off conveniently, so they don't have to pay any wages, to come here, exploit the people, not pay them New Zealand minimum wage, take their houses and security like that, which is in breach of Section 12A of the Wages Protection Act 1983. They don't get any holidays, they don't get any holiday pay. They don't work like, in a way that's just, you're just not, nobody could sustain that in New Zealand. And then they were getting racially abused, bullied, the assaults, the rapes. It was just disgusting. So I'm trying to get them justice, and at the time that I'm talking to you out there in Facebook land or YouTube land or wherever it is that you are watching me today, today is the 8th of October 2016. So it's been a really long battle for these fishermen, and they've put a lot of faith and trust into me, and we're off to the Court of Appeal, me and all my files, to argue for justice to be done. And what I'm going to do in the next couple of videos is just go through some of the submissions with you so that you can understand what's going along. And we do need the support of the public to just appreciate that it is wrong for foreign workers to be brought to New Zealand to work and our fisheries waters to be exploited, not to be paid. Everyone must be paid the minimum wage per hour. And you can't say $200 a month salary covers working 20 hours a day, 7 days a week for 2 years. I mean, I've got dresses and jackets worth more than their annual salary. How sad is that? You know, the combined salary for the 2 years. You know, I've got dresses worth more than that. So, is this wrong? And it concerns me that the Ministry of Primary Industries sort of implicit in letting this wrongdoing carry on by fighting us about the vessel. I mean, they're not saying, oh well, you can't apply this as to ship, but that's okay, Karen. We'll sell it and we'll make sure they get paid their wages. No, none of that. None of that at all. There's affidavit evidence proving the unpaid wages. I have the bank statements as well now. I know they were paid. I know what they were paid because I've actually got bank statements about it. I've got copies of these contracts that they signed. I've got copies of the security arrangements. I've got photographed some injuries, and just overwhelming evidence on oath about what's happened. And the Crown Solicitor's had this in his office since 10 April 2015. They've done nothing with it. You know, it's criminal what's happened here. And the authorities are really just doing nothing. No one cares. No one cares about Indonesian fishermen. And it's a round the world problem. And it feeds into something called human trafficking, because what's happening here is they were working under the menace of a financial penalty. So they started off voluntarily. They're not really free to leave, because if they leave, then these houses, cars and other assets that have been put up are going to be seized. And you're going to go, if you went home and said, oh, I'm sorry mum and dad, look, I can't put up with being raped on the ship, it's just, not for me, and I'm quite traumatised about the whole thing. Oh my god, I'm sorry, we're all going to be homeless now, live on the street. I mean, you wouldn't, you just carry on being put up with all this terrible things that are happening to you. We know everyone was raped on the ship, but it happened, and some people watched it because they were in cabins with bunk beds, and so they saw what was going on. They had to bathe together, and it's just humiliating. And is this the kind of country New Zealand wants? Is this the kind of country New Zealand wants? It isn't. So that's why the government's been running around changing the laws to reflag the foreign vessels to be now New Zealand flagged vessels, and they're going on, everyone's going to be paid minimum wage. But the thing is, we have some laws, but they're not being enforced. And the other thing is, like, we're telling you they're not paid, and I've got proof. And then you block me. I'm not having it. And I expect in the Court of Appeal that the Court of Appeal should rule in our favour, because the justice of the circumstances requires that these forfeited vessels be sold to pay the wages. It's the only just thing to do. It is not just to return it to criminal owners who put profits over people. And the Ministry of Primary Industries have told me they only care about fish. Well, I do praise them for the fact that they made this fisheries prosecution, because in making the fisheries prosecution it led to the vessels being forfeited, which is the only way my people can get paid. And we're simply asking for New Zealand to stand with us to ensure justice gets done. Thank you.